And I want to start off by welcoming everyone to our April Security Speaker Series lecture. We're recording this lecture and questions for public viewing on our YouTube channel. I'm Dr. Jim Novak, Director of UNM's Global and National Security Policy Institute. GNSPI is a cross-campus collaboration of undergraduate and graduate courses, research, and programs in security topics. We bring together UNM's diverse faculty, researchers, and students to address emerging threats and challenges to global security. Our mission is to enable faculty research to inform policy thinking and decision making, and to prepare our graduates to become key security policymakers and influencers. This security speaker series is a forum to hear from experts in a wide range of security policy domains, including nuclear, cyber, space, remote sensing, intelligence, law, governance, foreign relations, health, environment, and emerging technologies, including directed energy and artificial intelligence. Through our activities, GNSPI is working toward a vision of a more secure and prosperous world. And now it's my pleasure to introduce Joshua Kastenberg, JD. He is currently a professor at the University of New Mexico School of Law and a visiting adjunct professor at UNLV. He's had a 20-year career as a lawyer and judge in the U.S. Air Force. He served as advisor to the Department of Defense on cybersecurity and cyber warfare matters, twice deployed to Iraq, and oversaw the military's compliance with international law. Professor Kastenberg served as prosecutor and defense counsel in over 200 trials and as a judge in over 200 trials. He's been cited by the Washington Post and appeared on Fox News and written over a dozen law review articles as well as 4 books. Professor Kastenberg's interests are in the field of criminal law and procedure, evidence, legal history, and judicial ethics. Please help me welcome Joshua Kastenberg.
Well, thank you very much for that wonderful introduction, Dr. Novak. And it's an honor and a pleasure to be able to be a part of this series and put on a presentation. The topic that I'm going to cover tonight actually touches on legal history, national security, criminal law, and ethics. And I think, 1921 was a long time ago. I mean, the span of human history, a century isn't that long, but the way the world has developed since 1921 has been a long time. And yet the scandal that occurs in Washington, D.C., specifically in the presidency of Warren G. Harding, still affects us today. And it affects us today because of how the case is navigated through the Supreme Court, the challenges against the scandal, and where we are with that today. So if we go back to the United States' national defense, the United States' national defense as it stood in 1920, and the period of time from the founding to 1920, the United States was defended by its Navy. The U.S. Army was very small. In the War of 1812, of course, the British invade and capture parts of Maryland before leaving. But by and large, the Navy was the instrument of the military, the frontline instrument of the military, and it makes sense. It makes sense because Canada is barely populated. Mexico was a Spanish colony, and when it gained its independence in the 1820s, it never really posed a threat to the United States. The governing structure of Mexico could be rather dysfunctional at times, and the European powers sought to get it back to the point where in 1863, the French landed forces there and installed an emperor on and created a throne. But it was the Navy that guarded the nation from the Europeans. It was the Navy that defended the Monroe Doctrine, and the Navy was quite small. Until the 1880s, the United States Navy, like other navies of the world, operated on sail power, wooden ships, cannons that fired broadside. It was a fairly good instrument of defense, although it was small. It was nowhere near the largest navy in the world. At the time, the largest navy in the world, of course, was the Royal Navy of Great Britain, followed by the French Navy, followed by Prussia, which becomes Germany. Even the Russians have a bigger fleet, but it's hard to get a large fleet across the Atlantic Ocean, or for that matter, the Pacific Ocean. But as a result of technological changes in the 1880 because of the products of the Industrial Revolution, ships are being built out of iron and they're powered by coal. And later they're powered by oil. You know, the weight of the HMS Victory, which was Admiral Nelson's warship at Trafalgar, was a mere 2,800 tons. And you can see a picture of it. The weight of the USS New Mexico, which was constructed and launched in 1916, is 29,000 tons. There's a huge difference between the weights of those two vessels. You may think of oil, as I think of oil, in the turn of the last century, in this picture of Daniel Day-Lewis, who starred in the movie There Will Be Blood. And Daniel Day-Lewis's character is actually based on a character who's central to the Teapot Dome scandal, a man by the name of Edward Doheny. Edward Doheny is remembered because he went to jail, but he's also remembered because he was one of the earliest founders of my undergraduate's rival, the University of Southern California. And you see a picture of Teapot Dome in Wyoming, and there's an incredible oil bed under that. And you see a picture of Elk Hills, California, and the lower part of that's another oil field that's central to this scandal. Doheny and the other individual, the other big oil man involved, Sinclair, were not the biggest oil men in the country. Those were men named Rockefeller and his family, Standard Oil, Carnegie, for example. But Doheny and Sinclair were the giants of the West Coast. And this is going to be important because there's a tie to New Mexico, and it's going to be important about how they get caught. So before proceeding, imagine for a moment, and this is the national security aspect, a Secretary of the Army, Secretary of the Navy, of the Air Force, or today of the Space Force, pockets bribe monies from a major corporation in exchange for the corporation doing business with the United States, and national security is at stake. And if you say to the general public, do you think it's possible that the Secretary of Defense or the Secretary of the Army is capable of taking bribes? And they'll say, oh, that'll never happen. Well, it did. It did in the United States. And actually, it has in other areas. For those of us who are a bit on the older side, we may remember that Lockheed Martin, when it was just known as Lockheed Aerospace, bribed the West German government to buy those jets. Those are F-104 starfighters, because the United States Air Force said, you know, there are a lot of pilot deaths as a result of that plane. It's not particularly stable. Well, it would have shut down Lockheed's production lines to have had to retool and design something else. So what did Lockheed do? They bribed the Japanese prime minister and they bribed the West German minister of defense in 1971. And the Japanese prime minister and the West German minister of defense were convicted and off they went to prison. So when someone says to you, it's not possible for a democracy to survive when the leader of the country is prosecuted, you can always answer them, well, the Japanese seem to be doing really well today, and yet they went down that path. Well, essentially what happens in Teapot Dome is similar. You have a Secretary of the Interior who gains control over the Navy's strategic petroleum reserves and begins selling those petroleum reserves off in exchange for huge amounts of money. And it involves the Justice Department's leadership, the Attorney General, it involves the President, who's now dead, Warren G. Harding, and it involves a whole host of others. And we'll get into how it undermined the national security of the United States. To understand that, let's go back to the beginning, as I already mentioned. If you go back from the end of the War of 1812, that's 1815 to 1897, you can understand why a navy is critical to the national defense. In order to keep the European countries away from the United States, in order to enforce the Monroe Doctrine, which was really an effort to push them out of the Caribbean and Mexico, and then later South America, the United States is going to have to rely on a navy. The way the United States early on, the leadership constructed the Navy is that they didn't. They relied on mercenaries. And it's not until 1798 where a naval department is created. After the War of 1812, it becomes clear why a navy is important, because for the only time in United States history, the continental United States is shelled by a large Navy. I know the Japanese, a submarine shelled the Santa Barbara oil fields in World War II and fled. And of course you have Pearl Harbor, but the continental United States is actually attacked by the Royal Navy, and British Marines and soldiers land in Bladensburg, Maryland, and they march to Washington, D.C., and they burn some buildings, and then they leave. After that time, Congress pours all sorts of money into the Navy and builds coastal forts and the like to ensure that never happens again. In 1842, Congress empowers the Secretary of the Navy to establish and construct coal depots. And that's important because that's the first grant of authority that Congress specifically gives to an agency to construct ports and coal depots. And that doesn't just mean coal depots in the United States on the coast, it means all around the world. So the United States holds some minor islands in the Atlantic, and they put coal depots there. And when the United States grows and takes over areas like Hawaii in the 1890s, the Navy begins to move into those areas after ports and coal depots are built. Coal means fuel, fuel means oil. And as the United States grows, so grows its Navy, and so grows the need for coal and then later oil. Coal's easy. You mine it in West Virginia or Pennsylvania. Oil's not so easy. In 1883, President Chester Arthur asked Congress for funding armored warships. So up until that point, the U.S. Navy is going on steam, and coal are going on sale with some boilers that are giving a little bit of power. But in 1883, the United States gets its first steel ships. Commensurately, the United States, and I know can be a contentious term, contemporaneously, the United States begins to become an imperial power. And I know that there are individuals who will say the United States was never an imperialist country, but with the Spanish-American War, the United States extends its reach into overtaking the Philippines, Guam, Cuba, and Puerto Rico. Now, that's imperialism, in my opinion, because those are sovereign lands of other peoples, or they had been held by Spain. But certainly the Filipinos wanted their independence. They waged a war against the United States to get it, and they didn't succeed. In 1885, the first armored warships, known as the ABC fleet, because they're named Atlanta, Baltimore, Columbia, and Detroit. So it's the ABC fleet are built. In 1897, the war with Spain occurs. The United States defeats the Spanish Navy, both in Cuba and outside of the Philippines. And as I've mentioned, areas in the Pacific are seized. Shortly after, the United States teams with Britain, Germany, Italy, France, and Japan, and sends military expeditions into Beijing. There's a rebellion going on in China known as the Boxer Rebellion. The Dowager Empress supports it, and Europeans are getting killed in the capital, in the embassy area. So it's not entirely an unprovoked military expedition, but as an important and non-trivial matter, President William McKinley orders the military to go in without a grant of authority or funding from Congress. And so that's enormously contentious. 1981, in 1901, there's a brief war scare with Chile. And in 1913, there's a brief war scare with Japan. So as the United States develops policy, defense policy, and it centers on the Navy, it relies on the writings of a man named Alfred Thayer Mahan. And Mahan is there. He's a retired admiral. And what Alfred Mahan decides or advocates is that in order for the United States to protect itself, protect its commerce, protect its overseas holdings, it has to build a bigger and bigger and bigger Navy to rival Great Britain. And it needs to convert to oil from coal, because oil doesn't create smudgy smoke. You don't need as big of a crew. Oil-driven ships are more powerful. They go quicker. They can be built with heavier displacements to them. And so we need bases all around the Pacific and in the Caribbean. And we need oil fields. And so the Navy begins to search for fuel, and it finds fuel in places like Wyoming. And it is, for a process that I'll get into in a minute, it actually takes control of oil fields based on congressional grants of authority. So I mentioned Alfred Thayer Mahan. He has a big ally in the White House. That's Theodore Roosevelt. Theodore Roosevelt wants to flex naval power around the world. He's a believer in deterrence. Don't threaten people unless you can. Walk softly and carry a big stick. So he gets funding from Congress to build the Great White Fleet, which is a fleet of battleships, and they sail around the world after he leaves the White House and Taft is president. A whole independent group, pressure group, lobbying group is formed around this, known as the Navy League. They pressure Taft, and then they pressure Wilson to build bigger and bigger numbers of ships. And in 1916, the year before the United States declares war on Germany in World War I, President Woodrow Wilson announces that the United States will build a Navy second to none. So he gets a huge appropriation from Congress to build the biggest Navy in the world, one that will not only rival Great Britain and their Royal Navy, but one that will exceed it. By 1916, the ships had gotten bigger, and this is before the aircraft carrier is thought of as being a possibility, really. The ships, the big ships known as capital ships, are battleships, and they weigh a lot of tons, 30,000 tons. They have guns that are up to 15 inches in diameter that can hurl destructive cannon shells to the range of almost 30 miles, and they're getting more and more accurate. And countries like Germany, Italy, France, Japan, Russia, Britain, and the United States are in a naval race to build these. To show you the advances and the need for oil, I have these comparisons. In 1910, the Philadelphia Naval Yard builds what's known as the Delaware-class battleships. They're coal burners. They weigh 20,000 tons. They have an 11-inch armor at their torpedo belt line. They have 12-inch guns. They can sail at about 20 knots at fuel speed, but they can't refuel at sea because you can't stop a coal ship to refuel. You got to take it into port. And there are hundreds of sailors who are working in the boiler room shoveling coal. Just 4 years later, the Nevada-class battleship is produced. It's the first oil-burning battleship to create steam. It doesn't create smudges. It runs relatively silent. It has an additional 7,000 tons, more armor, bigger guns, and it goes roughly the same speed, and importantly, fewer crew. So this is a technological advance. Now, the early planners of American national security understood that Japan could be a likely enemy in the future. Now, Roosevelt and Taft tried to avoid that from happening, but they understood that as the United States was becoming an imperial country, so too was Japan. As the United States seizes the Philippines, the Japanese government sort of accepts it because they had wanted the Philippines themselves. But they expect a free hand in Korea and in China. And in fact, in 1884, the French go to war with China and they're losing, and the Japanese ally with the French and help turn the tide of the war in France's favor. In 1894, the Japanese military invades China in the first Sino-Japanese War and removes China from Korea and gains control over the Korean peninsula. In 1904, Japan shocks the world by defeating the Russians, and it was unheard of for an Asian country at that time to defeat a European power, but they do. And in order to create a level of peace, Roosevelt sends the Secretary of War to Japan and enters into a secret agreement known as the Taft-Katsura Agreement. Katsura was the Japanese prime minister, and they agree that the United States will recognize Japan's sovereignty over Korea and parts of northern China in exchange for Japan recognizing the United States maintaining control over the Philippines. It's like one of those dirty European treaties that President Wilson argued caused wars. The United States are in one of those too. But the United States and Japan weren't likely to remain allies. And there's two fundamental reasons for that. And Wilson understood that, Taft understood that, the Japanese certainly did. The national security apparatus in the United States certainly understood that for two reasons. One is that the Japanese government itself was militaristic. They had adopted sort of a Germanic type policy of foreign affairs. But the other, and equally, if not more important, and it's important, I stress this, Japan's view of the United States was it was an inherently racist country. On the West Coast, Japanese citizens, including United States citizens of Japanese descent, were prohibited from buying homes in California, from voting, from going to white schools. And the West Coast states had done that. And there was very little the federal government was willing to do to stop it, other than to say this is causing a rift in foreign relations. And at the Treaty of Versailles, the Japanese wanted to be treated as equals. They wanted a statement in the Treaty of Versailles that the people of Japan are the equals of the people of Europe and the United States. And the British, the French, and the Italian governments were willing to go along with that. But you know who wasn't? It was Wilson. And President Wilson moved to veto that. So it was very likely that there would be a clash of countries based on the Japanese perception of the United States and on Japanese militarism itself. 1920, President Warren Harding sweeps into office. The United States, those who could vote in the United States, including white women for the first time, were sick of the war, and they wanted a change of the progressive era, and they swept Warren Harding into office. He's not one of the brighter people we've had sitting in the White House. He liked to have a good time. He certainly didn't follow the prohibition rules, but he promised an end to militarism and an attempt to reduce the arms races. And so he did get the major countries of the world together to agree on naval arms limitations. But another thing he did was to govern by executive orders, something that Republicans today often decry that Democratic presidents have done, meaning they don't go to Congress and they simply issue executive orders. And there's some justification for those arguments today. Harding was the master of that. And this involves Teapot Dome. So under the General Mining Act of 1872, oil fields were viewed as the public domain. Taft, as a president, decided that was a bad idea and issues an executive order setting aside Elk Hills in California and Teapot Dome in Wyoming for the Department of the Navy. Oil field prospectors and corporations sue the federal government, saying he doesn't have the power to do that. Congress steps in and creates laws. They authorize him to do that through lawmaking. And in 1915, the Supreme Court upholds the federal government authority to set aside lands for the Navy, for the national defense. And it's amazing to me that it's the first time the issue came up in U.S. history, but it does. So those oil fields were set up and protected for the use of the Navy by the government and approved by the Supreme Court. But in 1922, Senator John Kendrick of Wyoming is informed by Standard Oil, the biggest oil corporation in the world, that two private oil corporations are drilling on the Naval Reserve lands without a contract bidding process and without permission from Congress. So he and Senator La Follette of Wisconsin decide they're going to investigate. And the day after their announcement, their offices are ransacked. There was some dirty pull going on in Congress. The next day, or by the White House, the next day, the Senate voted on a resolution and they appointed Senator Thomas Walsh to read it. Now, Albert Fall, who was a senator from New Mexico originally and becomes Secretary of the Interior, secretly had gained control of the oil fields. And the New York Times broke the news with the headline that the oil fields going under Fall's control would be investigated, and the Chicago Tribune headlined "Interior Reeks of Graft." And here's why. The public assumed that the Department of the Navy was still running the oil fields, but Harding issued a secret executive order transferring the oil reserves from the Navy to the Interior Department. Fall was a fairly poor man. Within months, he owned ranches in New Mexico, shares in railways. He became very wealthy in a short period of time. Harding refused to provide the executive order to Congress until June the 9th, 1923, and he was already in trouble over a scandal at the Veterans Administration. He dies, though, before Congress can begin its investigation, so Congress focuses on Albert Fall and the secretive executive order. Here's what happens. Fall had been in debt, and Doheny and Sinclair, who are the two big oil men, give him loans and buy him ranches, shares in railway, shares in other oil companies, and he suddenly becomes very rich. There's a filtration of money in Liberty bonds, wartime World War I bonds that go under this just recently registered company in Canada called the Continental Trading Company, right into the Midwest Bank of Cincinnati, Ohio. And those monies then go to Fall and some others. President Coolidge, who's taken over, gets concerned about this, and he appoints two investigators, Owen Roberts, who will later become on the Supreme Court as a justice, and Atlee Pomeroy, who had been a Democratic senator from Ohio, but had been voted out of office. In response, Harry Doherty resigns. Now, he claimed he resigned in protest, but guess what? His younger brother, Mally Doherty, was the president of the Midwest Bank of Cincinnati, Ohio. Into this mix, the Navy had opposed the transfer of their oil lands from their department to the Department of the Interior. The admiral in charge of the Bureau of Steam and Engineering, which was the part of the Navy responsible for oil field management, protested, and that admiral was dismissed and forced into retirement. The Secretary of the Navy, on Fall's advice, put Captain John K. Robeson in charge. During World War I, Doheny's son was Robinson's aide. In 1923, Robeson tells the New York Times that the transfer of lands to private oil control to private oil corporations was, quote, beneficial to the national defense. And he also inadvertently noted to the New York Times, by the way, part of the deal is that Sinclair is building big oil tanks for a future Navy base at Pearl Harbor. Up until that point, Japan had no idea what the United States' plans were for Pearl Harbor, but they too read the New York Times. Their ambassador did. And there's quite a lot of traffic between the ambassador and Japan about this big Navy base that's provocative and it's going to be built in Hawaii. The Senate then jumps back into the investigation when they discover the Midwest Bank is run by Attorney General Doherty's younger brother, Mally Doherty. So they issue subpoenas to Harry Doherty and Mally Doherty. And all of the senators on the committee sign the subpoena. It's bipartisan, but the Dohertys refuse to comply. They say, we're not going to come and testify to you. Mally Doherty, as I mentioned, is the president of Midwest Bank, and he's getting money. He's gaining wealth. Harry Doherty is getting wealthy. He refused to investigate his younger brother as Attorney General. And Captain Robeson said, I'm not going to testify because there are too many secrets and it's a national security matter, which is sort of funny because after he blabbed to the New York Times, he's now claiming national security. Now, President Coolidge was more concerned with getting the leases broken and going back to the Navy Department than he was with corruption and national security. So he commands Pomeroy and Owen Roberts to sue to get the oil fields back and have the leasing contracts broken to the two companies. There are two district court cases in 1925, Pan American Petroleum in Los Angeles, and the government wins on that one, and United States versus Mammoth Oil Company, and the government loses on that one. The interesting thing about the win in California is the judge who sat on the case had just been appointed by Coolidge to sit on the case, and he writes a very brief opinion that basically said, now, you know, these oil field leases were given by bribe and corruption, so the contracts aren't valid anyway, so I don't have to spend a lot of time ruling on this case. In contrast, Judge McCormick in Wyoming insisted that Albert Fall and everyone else acted in good faith and that he respected Robeson's assertion of secrecy. He called the investigation wrong-headed. The Canadian Supreme Court had already ruled the Continental Trading Company was a fraud and had collapsed that corporation, but he refused to give any acknowledgement to that fact, and he sides with Mammoth Oil and Sinclair. That's going to tee up those cases to the Supreme Court. These cases, to me, are important for one reason alone, before we get back into the corruption. The Supreme Court determines that the United States government, in the name of national security, can shred or void contracts for the convenience of the government. And they do this unanimously. All 9 justices who sit on this case, from the liberal Brandeis to the conservative McReynolds, agree that the federal government is different than any other contracting party. And when the Army or Navy enters into contracts with defense corporations and something is amiss that'll harm the national security, which includes the economy, they can remove themselves from the contract for the convenience of the government. Now, if you enter into a contract with a construction company or two corporations contract with each other, they can't void the contract for that. Contract law is very specific on remedies for failures to comply, and there are all sorts of financial penalties that can be involved, but those don't exist. And that case has enabled the United States to break contracts for such things as aircraft carriers, fighter planes, bombers, and it can leave the contractor in the lurch. And the U.S. government has done that before. They did that with a bomber known as or fighter plane known as the TFX, and it really harmed Boeing for a while that occurred. The other case is more important to me, and I think more important to the national defense for another reason, and that is exactly what does Congress have the power to do? It was always assumed that Congress had the power to investigate wrongdoing. It was always assumed that Congress had some sort of power to keep the executive branch in check. But no one really understood what that power was, other than those who tried to assert it, because it's not plainly written into the Constitution. Congress can act in aid of legislation, meaning they can investigate things that will help them create new laws or get rid of old laws. But if all Congress does is investigate, then there can be no liability. And I'll give you an example. You may remember when Major League Baseball was first accused of allowing steroids to be used. And Senator John McCain headed a committee. It was one of the Commerce subcommittees. And they called Major League Baseball players, and they caught Jose Canseco in a lie. They caught Mark McGwire in a lie. They caught Barry Bonds in a lie. But you know what? Because Senator McCain never announced, or nor did his committee, what the end game was of that committee, new legislation, maybe getting rid of baseball's antitrust exemption, those lies couldn't be prosecuted in a court of law. Now, Bonds lied in a different proceeding that was a criminal proceeding, and he could be prosecuted for that one, and which he was accused of lying, I should say. So Congress has to have an end state. So in 1818, Congress's powers first test. This individual named Colonel Anderson, and I've tried to track him down, apparently walked into Congress in 1818 and offered a bribe to a member of Congress and was overheard. Speaker of the House, Henry Clay, was upset and ordered the colonel arrested for the attempted bribery. And the Supreme Court upheld the Speaker of the House's power to do that because the crime occurred on the floor of Congress. The record is unclear as to why he was trying to issue the bribe. That's sort of one of those mysteries I spend time trying to understand. But nonetheless, it was a bribe. On the other hand, in 1880, the Supreme Court tried to compel a private citizen to testify as to his knowledge of corporate corruption that harmed the Navy, but Congress never stated the investigation was aimed at furthering legislation, which is my Mark McGwire, Barry Bonds, and Jose Canseco comment. 3 men who are not in the Hall of Fame, I might add. So the Supreme Court determined there that Congress did not have a general subpoena power. They have to have an investigation with law in mind. And this goes on. There's a case called Chapman In re Chapman that gives the court finds that if Congress finds someone in contempt, the courts of Washington, D.C. are the proper place to try the case. And they could also find if someone speaks contemptuously of Congress, they can't be held in contempt. So there's a sort of balance, and that was the state of the law. But what about someone who refuses to testify? So on May the 31st, 1924, the U.S. District Court for the Southern District of Ohio determined that Congress did not have the power to compel either Mally Dougherty or his brother to testify. The Attorney General of the United States, who had retired, this George Wickersham, but was named as a special counsel, gave the following argument to the Supreme Court, which is, can it possibly be said that the discovery of any fact showing the neglect or failure of the Attorney General or his assistants to properly discharge his duties imposed on them by law cannot and would not naturally be used as Congress as the basis for new legislation safeguarding the interests of government? And in this case, the interests of government were the national security of the United States. And he made that point to the Supreme Court, which unanimously will uphold Congress's right to investigate corruption in the government, in the executive branch. But there's an interesting side note on this case. Speaking of corruption, we want our Supreme Court justices to recuse themselves in cases they have an interest in or that they're too close to one of the litigants. And this is Chief Justice William Howard Taft, who'd been president. And one he failed to note on the record, and one he didn't recuse himself from, although he did rule against the interests of the individual. Can anyone guess what the problem is with Harry Doherty and William Howard Taft? This is a good trivia question. When William Howard Taft ran for president in 1908, guess who his campaign manager was? Harry Doherty. He should have recused himself from that case. In the end, it didn't matter because the Supreme Court unanimously found that the United States Senate had the authority to investigate. And it's out of this case, McGrain versus Doherty, that the Senate Armed Services Committee, the House Armed Services Committee, and the respective judiciary committees today have the authority to investigate government contracting in the defense industries, have the authority to investigate, military policies and procedures, have the ability to investigate just about anything involving the national security or the intelligence community, and the failure to comply with subpoenas are punishable by contempt. And contempt is a criminal conviction when someone is held with it. The Supreme Court understood fully what was at stake here. What was at stake here to them is that you had corruption in the defense industry or at the periphery of the defense industry that would undermine the national security of the United States and ultimately expose to potential future opponents of the United States, and the most likely one was Japan at this time, exactly what United States policy was. In this case, United States policy was to have a big fleet of battleships in the Pacific Ocean, and at some points along the way, a good sizable fraction of them would be docked at Pearl Harbor. Up until this time, there was no idea that Hawaii would become an enormous naval base. To the Japanese, building a Navy base in Hawaii, which was not a state at that time, but rather a territorial possession, was provocative. It was provocative because the Japanese fleet stayed in Japan. To the United States, under the strategy set forth by Theodore Roosevelt and Alfred Thayer Mahan, Hawaii made sense because Hawaii was the jumping off point. It was halfway across the Pacific to fight against a future enemy, that future enemy, again, being most likely to Japan. I mean, there was some talk that it could be Russia in the Pacific, but generally it was focused on Japan. That corruption not only undermined the Navy and resulted in spilling some of its secrets, but during the course of the trials, which were open to the public at that time, the depth of the bottom of Pearl Harbor came out. The thickness of naval armor was a feature that came out in the district court cases. The range of battleships, the speed of battleships, how they refueled at sea, how many giant oil storage units were held at Hawaii. All of that came forward. It was all a matter of one man's corruption and his enablers, Albert Fall and his enablers, that revealed that to the world, the interested world that wanted to know. Now, in the world of Calvin Coolidge in the 1920s or President Herbert Hoover, it didn't seem like that big of a deal. And the reason it didn't seem like that big of a deal is even though secrets were lost, the world wasn't really at war in the 1920s. You look at the Roaring Twenties and you have people calling World War I the war to end all wars. We'll never fight another war again was the mentality. The last one was so bad, we've really learned our lesson. So they went about prosecuting Fall and Doheny and Sinclair and some others, but it took until the early 1930s for those criminal cases to work their way through. Doheny kept his money and retired very wealthy in California, where he bought enormous art collections and built buildings for the USC Trojans. Sinclair bought new oil fields in Mexico, took over oil fields in Mexico and Canada and Venezuela, became incredibly wealthy. Fall died a poor man. Harry Doherty became a wealthy lawyer. His brother Mally Doherty remained president of the Midwest Bank after he served no time in jail. He was convicted, but he served no time in jail. And it seemed like the country passed by Teapot Dome and the scandal without really thinking about the long-term damage that it may have caused. Now, for historians and political scientists and lawyers who practice in the field of corruption, prior to Watergate, Teapot Dome was the biggest scandal in American history from the White House, but it receded into the background. I mean, the world that comes out of World War II for the United States is the modern world. Teapot Dome is it occurs in a time of speakeasies and jazz bands and people violating, bathtub gin, violating prohibition. President Harding, who had a 16-year-old mistress named Nan Britton, and their salacious letters between the two of them are housed at the Library of Congress, and they're now online if you want to read those letters. They're really something to see. I read those letters online. But it was a different world back then, and yet what comes out of that is a legal construct that when Congress does its job well, it can investigate not only corruption, but fraud, waste, and abuse, which isn't necessarily corruption in federal contracting. And the President of the United States, through the Attorney General, also in Congress as well, plays a role in this, can void contracts that are detrimental to the national security of the United States in a manner that they can't void contracts in anything else. So as an example, if the United States entered into a contract with a railroad company today, and tomorrow there's a military conflict with Russia over Ukraine, the United States can seize can't seize the property in the railroad contract, but could certainly break the railroad contract for the convenience of the government, not be held liable for the loss. The way corporations deal with that is they have insurance, and insurers like Barclays and Lloyd's of London have policies that protect corporations that do defense contracting. That enabled the United States Air Force or the Department of Defense to say to Lockheed, yeah, we originally were going to buy 750 F-22 Raptor aircraft from you. We're going to decide to stop at 105 because we really think that we have to use our money in a different arena. And by the way, you can't sell those to foreign governments like you can to other aircraft. How do we know all of this? Well, we know all of this because William Howard Taft and others kept their papers. And their personal papers, these are Taft's, are at the Library of Congress. And in several letters to his son, Robert Taft, who later became a United States Senator, and to friends that Taft had in the government, he really focuses on the national security aspects of all three cases that come up and why it's important as the United States has become a superpower to give both Congress and the presidency these powers. So the lessons of this mess, to conclude, is that the Teapot Dome scandal itself undermined confidence in the government. And I would argue that that alone is a national security matter. But more specifically, it involved the Navy and it exposed secrets. These men didn't intend to have secrets exposed. They intended to get rich. But they did expose national security secrets. But on the other hand, the court strengthened two powers of government, the power to investigate through Congress and the president's broad power to terminate contracts for the convenience of the government. Just to conclude on that, before any questions might arise, because I'd like to leave the last 10 minutes or so, the scandal also highlighted to a potential enemy, and in this case, a real future enemy, that the national defense would solely rely on a specified manner, in this case, Pearl Harbor. And I know for those people who read like Gordon Prang's classic, Tora, 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 which became a movie. He was a brilliant historian. And they focused on Japan's war planning to attack Pearl Harbor as having occurred in 1940, the first year of World War II. The Japanese military is looking at Pearl Harbor from the time of this case as a potential problem for them. And even though they're not specifically developing war plans, they're beginning to study it, and they're beginning to study what it would take to get submarines out there to blockade it, or whether the Japanese could ever build a fleet that would blockade Pearl Harbor. And they're beginning to understand how the United States would go to war. And the lesson out of that you see from December 7th, 1941, where the Pacific Fleet, at least the battleships that were part of the Pacific Fleet and their support vessels, are destroyed in the course of a couple of hours in a sneak attack. And with that, I'll conclude this presentation. I hope that the presentation was worthwhile and enjoyable, and I'll be happy to answer any questions. I will say this, for my students who have me, and for others, I tend to be a historian trapped in a law professor's body. And so I try to approach this history, but our law, if it's based on anything, it's based on the history that comes before it. And there's almost nothing new. And this includes the investigations into the former president, President Trump, during the Ukraine Alexander Vindman scandal. This includes the Clinton scandals as well. And the basis for the power to investigate those rests in the Teapot Dome era and the case law. So for that, any questions or comments?
Thank you, Professor Kastenberg. I'll start off with one question. It looks like a lot of the, call it, national security information about Pearl Harbor was released in court proceedings.
Yeah.
Is there any evidence that that information was used, say, in a broader sense by U.S. companies seeking to build condos in Pearl Harbor or something like that?
Yeah, that's a great question, and the answer to that is yes. Corporations like Westinghouse and Babcock and Wilcox, major construction corporations, were shaping their contract bids based off of what they were learning in court for the port expansion, or for the buildup of airfields for the Army Air Corps and the like. As a side note, there's a case that can show you how the courts and lawyers can really botch an important thing in national security, that the lessons weren't learned from the Teapot Dome scandal, maybe because they weren't known. But in 1938, there's a case that goes to district court called Sperry Systems versus Dudman, and Dudman insisted that he held the patent and agreed on an invention called the Norden bomb sight. Now, if you're dropping bombs from an airplane, you really have to be a brilliant mathematician to understand wind patterns and the speed of the plane and the like. And Dudman was a scientist, and he developed one of the earliest, what I'd say, calculating systems, a proto-computer that took all of those into account. And it was revolutionary. The Germans didn't have it. The British didn't have it. When he sued the Sperry Rand Corporation, because when he left over that, the court was open. And this secretive thing that was important, the patent and the designs for it, were being argued in open court. And Germans, Soviets, Italians, Japanese could have sat in there and obtained that information that had actually been classified, but not in court. So we have a funny, the Sixth Amendment in the Constitution gives a defendant the right to a public trial, but it's also the public's right. And I don't know, nowadays we have systems called the Classified Information Procedures Act, which would enable courts to close for those sorts of things. But at the time, the courts were open and fair game, and there was all sorts of patent poaching and contract sort of thing going on. But that's a great question. Yes.
Thank you. Are there any other questions? Anybody there's nothing in the chat right now. If you raise your hand, we can.
Well, I don't know what else I could say about everything, but I could say this, that when you hear individuals say this investigation's unfair, that these cases really don't cover that point. They cover the authorities of government. And one thing I'd add on in regard to Congress is Congress can do a lot of things because they're protected by the speech and debate clause. So unlike the other two branches of government, Congress can actually libel you, and they're free from lawsuits because the framers of the Constitution didn't want Congress to be bullied the way Parliament had been bullied by the king.
Mhm.
And so with this great authority also comes a shield. I noticed we have a couple of questions in the chat. So how did I get onto this topic? Well, a couple of reasons why. One is from time to time during the Trump administration, the BBC would ask me questions about this investigation or that investigation. And I kept going back to the McGrain case and the Teapot Dome scandal and sort of explaining why Congress had the authority to investigate. And then the University of Kansas press asked me if I'd write a book on it. And so I said, sure. But to me, I got onto it because I'm a big believer that when you teach law, that there are two types of lawyers. There's a lawyer in court who cites a rule and sits down, and then there's a lawyer that not only cites a rule but explains where the rule came from, and when they're objected to, can draw great analogies to the past. The first kind of lawyer can succeed, but I'd call him a mediocre lawyer. The second kind of lawyer is more likely to succeed in their cause of action that they represent a client for, but they've really done their homework and served their clients well. And I'd call that kind of lawyer a great lawyer. And so I try to use legal history wherever I can when I teach the law students on that. You know, some students want to know the rule and what does it take to pass the bar exam and move on. And you can succeed as a lawyer, but I'm convinced you don't do your clients justice. And so I try to do these historical backgrounds on the major cases and the major laws to explain it to them. So it's those three reasons. Can I think of more recent cases, issues that have busted open the investigatory capacity of government or public? So a couple of things. FOIA, Freedom of Information Act litigation is new because the Freedom of Information Act law comes about in the 1970s. And what I'd say about it is it's an important law, one of the most important things Congress did in the post-Watergate era that allows you to sue to get government information except for various categories. That, however, the courts are more and more siding with the government portion of refusing to hand over material than they have in the past. So they're kind of hurting FOIA more than helping it now. You know, I think FOIA, when FOIA is done at its fullest, it's supposed to build confidence in the government. I don't agree with a bunch of the recent case law on it. So was the US divided like the Imperial Navy, two schools of thought? Yeah, actually, the US Navy had three schools of thought. There was the big Navy battleships, and the US Navy, many of the admirals thought they could fight the Battle of Jutland, which was a major naval battle of World War I, over again. There were the carrier minded admirals who were in the minority, but ultimately they went out because once the battleships are sunk, the US Navy has no choice but to fight the war with the aircraft carrier at the center. And then there was a third group of admirals who I think and captains who I don't think get enough credit. And one of their members was Nimitz, and they were the submariners. And their arguments were often that the submarine is not just a raider to sink convoys the way the Germans had, but actually a tool of war to sink an enemy fleet. And the United States Navy, uses the submarine force in the Pacific as an adjunct to the aircraft carrier. They actually use them not as a commerce raider because the Japanese don't. I mean, they occasionally do, but the Japanese don't have big commercial fleets. But they use the submarine to do that. So yeah, there is a split. But the reason that the battleship captains and admirals lose out is really a fluke. It's that their prized vessels are sunk. And so that's a great question. But there is a difference though with the Japanese Navy and the United States Navy. And one thing I'd say is the militarists in the Japanese army had a tremendous amount of power with the emperor and with the diet, their legislature. The Navy, interestingly enough, didn't have that amount of power. In the United States, the opposite was true, but it was personality driven. Franklin Roosevelt loved the Navy. He had been Assistant Secretary of the Navy in World War I, and he loved ships, he loved sailing, and so he often gave the Navy an open audience in the White House. His view of the Army was, it's nice, but we don't really need a big one. And that was true until about 1939 with him. Okay.
Okay, I think we've come to the end of the questions. Thank you very much. Well, there's one more coming in here.
Makes you think of John Stewart interview with the Deputy Secretary of the Navy. The Navy has a problem keeping track of its assets. That's true. You know, if you ever spend time at a big port like Norfolk, you kind of understand that there's a lot of warehouses that look really old and you wonder, what are they using those things for? But they are stored with something.
Great.
Yeah.
Well, thank you, Professor Kastenberg, and everyone for attending. We really appreciate it. Thank you very much.
Well, thank you. And again, everyone have a great evening.
Thanks very much.